Circular 230 is the rulebook for practicing before the IRS. It tells you who can represent taxpayers, what standards you must follow, and what happens when you don't. On the EA exam, they love questions that sound like ethics, but they're really testing whether you know the specific Circular 230 duty that applies to the situation. Think of Circular 230 as 4 buckets. First, authority to practice. Who's allowed to represent taxpayers? Second, duties and restrictions. Your day-to-day rules like diligence and conflicts. Third, sanctions, censure, suspension, disbarment, and penalties. Fourth, disciplinary procedures. How OPR investigates and enforces. If a question asks, where is this rule found? It's usually in duties and restrictions. The core standard you'll see everywhere is due diligence under Section 10.22. It applies when you prepare, assist with preparing, approve, or file returns and other IRS-related documents. Due diligence is not try your best. It's a professional standard. You take reasonable steps to ensure accuracy. If something looks off, you ask questions, and you don't ignore red flags. Circular 230 also allows reliance on others, but only in a limited way. You're generally presumed to use due diligence if you rely on another person's work product, like a prior preparer's depreciation schedule, so long as the information doesn't appear incorrect, inconsistent, or incomplete. Exam tip: reliance is never a free pass. If it smells wrong, you must dig in. Best practices are in Section 10.33. This is broader than don't break rules. It's about high-quality representation. That means clear engagement terms, establishing and evaluating facts, applying the law to the facts, and communicating conclusions and impacts, like whether your advice could help avoid accuracy-related penalties. And if you oversee a firm, you must take reasonable steps to ensure your procedures support best practices. Competence is Section 10.35. You must have the right knowledge, skill, thoroughness, and preparation for the specific engagement. The key twist: you can become competent. You can study the law, get training, or consult an expert, but if you can't get competent in time, you refer it out. On the exam, the right answer often includes consulting or referring, not guessing. Marisol is an enrolled agent and employs 5 preparers. She discovers one preparer, Ethan, has been improperly inflating deductions on multiple client returns. Marisol immediately fires Ethan. Can Marisol be liable for Ethan's misconduct? The choices include yes. Due diligence penalties can apply to the firm, or no. Only Ethan can be penalized, or that Marisol is only subject to censure, or that she's protected if she notifies clients. Think about it. The correct answer is yes. Marisol can be subject to a due diligence penalty for a return or claim prepared by her employee. Circular 230 and preparer penalty concepts can reach the firm, not just the individual preparer. Firing Ethan is a good step, but it doesn't automatically erase potential liability for what was filed. A tempting wrong choice is only Ethan, but the rules don't limit it that way. Who is subject to Circular 230 jurisdiction? Options include just enrolled agents, or EAs plus CPAs and attorneys, or those groups plus AFSP certificate holders, or the broad option: attorneys, CPAs, enrolled agents, and any individual who submits a power of attorney for limited representation before the IRS. Which one matches Circular 230's reach? Think about it. The correct answer is the broad one. Enrolled agents, attorneys, CPAs, and any individual submitting a power of attorney in connection with representation before the IRS, even limited representation. The trap answer is the one that stops at EAs, CPAs, and attorneys only. Circular 230 can also apply when someone steps into representation by filing a POA, so the jurisdiction is wider than just the credentialed Big Three.